This is a series of bi-weekly webinars that we're doing in order to discuss key contractual issues. And in this session, we're going to cover force majeure and frustration, both topics that you may have heard about earlier this year, as there was a lot of discussion about them back in the spring at the start of the pandemic and during the first UK-wide lockdown. But we think it's worth revisiting these topics again, particularly given that here in the UK, we are currently experiencing a second lockdown, and which is having an impact on many parties' ability to perform contracts. And given also that the growth of the pandemic around the world is leading to further restrictions being imposed by governments pretty much everywhere. I say it's the second lockdown here in the UK, although I said that to somebody, one of my colleagues up north in Manchester the other day, who sort of pointed out that at least up there it's sort of been pretty much one big long lockdown. They didn't have quite the same level of respite that we did down south in the summer. I'm Eric France, a commercial disputes partner, and I'm based in the London office of Mills and Reeve, and I'm joined today by Mark Davidson.
Hi, I'm head of international arbitration, also based in the London office. A lot of my family are from Manchester, and I hear quite regularly that they've effectively been in some form of lockdown since the summer. So I appreciate the sentiments, Eric.
As always, there is a Q&A function. There's a button at the bottom of your screen. So if you've got a question, feel free to click on that and type in your question. And at the end, we'll try to get through as many questions as we can. Okay, over to you, Mark.
Perfect. So first, we're going to cover off force majeure before we get on to frustration. So turning to force majeure, I think as we all know, so force majeure clauses allow parties to escape liability if the reason that they can't perform their obligations under the contract is because a force majeure event has occurred. I've put up an example of a force majeure clause there on the slide. I'm not going to read it out, but typically, as you know, what you effectively get is a shopping list of unpredictable disaster events, plus often some kind of catch-all phrase. So the catch-all phrase here is at the start of the clause in the second sentence there, the second line there, which reads that it's acts beyond the party's reasonable control. So how do you know if your rights under a contract are affected by a force majeure clause, particularly if one or the other of the parties' ability to perform their obligations under the contract is being impacted, particularly by the new restrictions which are currently in place across the UK? So first, what you do is you would look at the scope of the force majeure clause. And what I mean by that is you should assess the wording of the force majeure clause and assess whether the COVID-19 pandemic or a change of law or regulation or an act of government falls within the scope of the clause. If the clause specifically refers to epidemics or pandemics, then it likely will cover that. But if it doesn't, then it will depend whether there is any catch-all wording in the clause that is broad enough to cover what has happened. So if the contract that you're dealing with was entered into since the start of the pandemic, then COVID and its continuing consequences may have been within the contemplation of the parties when they entered into that contract. That's a key difference to the kinds of situations that we were seeing at the start of the pandemic, when almost nobody could have predicted the pandemic or the consequences when contracts under consideration before they were entered into. So before the COVID-19 pandemic emerged, it just couldn't have been in the reasonable contemplation of parties that such a pandemic would have occurred. But in principle, just because COVID having some impact on the contract may have been foreseeable when recent contracts have been entered into, does not necessarily disqualify impacts like the second government mandated lockdown here in the UK from amounting to a force majeure event. It all depends on what the clause says. and whether it extends to pandemics or not, and how it's impacted by if there's wording in that clause as to the impact of government regulation or acts of the state. There are a couple of cases where the courts have effectively said that there's no justification for limiting the ordinary meaning of words in a force majeure clause to events that were not in existence at the date of the contract. They were both pre-pandemic cases and were both related to shipping. Most clauses don't require events to have been unforeseeable necessarily at the time the contract was made in order for them to qualify as force majeure events, although that's not the end of the story, as the following other requirements apply, which Eric is now going to come on to.
Okay, so the second thing you need to consider after you've looked at the scope of the clause is the causation requirements of the clause. So you need to consider what the clause says about the connection between the force majeure event and the reason why a party isn't able to perform the contract. So some clauses might require that the force majeure event has prevented the party from being able to perform. Others might allow for lower standards like hindered or delayed. And this can be really important because there may well be a dispute about whether it's the pandemic or the government restriction that is the reason the party can't perform, or whether it's down to some other cause, like, for example, the party's poor financial position before the pandemic started, for example. So the clause will usually also require that the party must make reasonable efforts to attempt to perform the contract before they can rely on the clause. So there's also usually a sort of an additional requirement there along those lines. Now, it's this sort of causation area is where parties may well be in a different position when it comes to this second new round of lockdown that we're experiencing compared to the first, because the pandemic's been going on for longer. That means that there's more scope to argue that the real cause of a party's inability to perform the contract is not the pandemic, but the party's failure to use the time between the start of the pandemic and the second lockdown to prepare. So what I mean by that is there are lots of different situations where parties could have taken steps in between the start of the pandemic and now to prepare. And if they haven't, then they're going to find it more difficult to argue that it's the pandemic that's caused their inability to perform the contract. So, for example, if you think about supply contracts, if the contract permits supply from any source rather than a particular source, it may be relevant as to the extent to which a party could have identified and changed to a source of supply that was likely to be less vulnerable to the second wave of the pandemic. If they could have done that, but they didn't, then it may be their lack of preparation that is the real cause of their inability to perform. Or in the context of a long-term maintenance contract for properties or facilities, there could be arguments about the possibility of rescheduling outages and maintenance activities to undertake operational critical maintenance before the second wave of the pandemic hit. And if a party hasn't done that, then that may be the real cause. So, and just in general, this time around in the second lockdown, there's likely to be more scrutiny on the ability of the affected party to have changed its operating practices, trained more staff, put up plexiglass, introduced one-way systems, adjusted working conditions, etc., to facilitate social distancing. And if they haven't done those things, then there's a much greater chance that they won't be able to claim that it's the pandemic that's caused their inability to perform. So this is really the key difference between force majeure arguments that we saw at the start of the pandemic and the challenges now of trying to invoke a force majeure clause 8 or 9 months later into the pandemic. It'll just be harder for parties to rely on a force majeure clause when it comes to satisfying this causation requirement. And equally, it's unlikely that courts will accept an argument that a contract has become less profitable to perform as a ground for arguing that there's been a force majeure. By its very nature, the party who's saying that a contract has become less profitable is confirming that they can still perform the contract. It's just that it's less profitable to do so. So that's continues to be an argument that the courts are going to be unlikely to be sympathetic to. So the next element of a force majeure clause is the remedy that it provides. And here you need to take a look at the force majeure clause that you're dealing with and consider whether the effect of the clause is to suspend the party's obligations for the period that the force majeure event is active, or whether it's to terminate the contract completely going forwards. Those are the two main types of force majeure clauses that you'll see: suspension clauses and termination clauses. If it's a suspension clause, then the party will need to carry on performing the contract after the effects of the pandemic subside. So depending on what remedy is provided by the clause, a party whose ability to perform the contract as a result of the second lockdown has been impaired may need to reconsider the notice provisions under the clause. So for example, if you have a suspension type force majeure clause in your contract and you want to claim that your obligations under the contract should continue to be suspended as a result of the second UK-wide lockdown, giving rise to a fresh force majeure event, then you may need to serve a fresh notice under the clause claiming that the second lockdown amounts to another force majeure event, suspending your obligations under the contract for the further period of the second lockdown. If it's a termination type clause, then some contracts provide for termination in the event of multiple periods of force majeure preventing performance for an aggregate number of days, might be 100 days or 150 days or something like that. If that's the case, you may want to consider serving a separate notice, even if you've already served one under the contract earlier in the pandemic, claiming that the second lockdown amounts to a fresh force majeure event, further impeding your ability to perform for the extra period of days that takes you over the total number that then entitles you to terminate the contract. If you are terminating a contract by relying on a force majeure clause, then you need to be very careful and you need to take expert legal advice first before serving a termination notice, because if you get that wrong and you serve a termination notice when you're not actually entitled to under the clause, then you could be sued by the other side for repudiating the contract, unlawfully walking away from the contract, which could give the other side the right to terminate the contract themselves and sue you for damages. So you need to be very careful about any decision you make to serve a termination notice under a force majeure clause. Over to you, Mark.
Perfect. So just moving on to frustration. When it comes to frustration, obviously there's no contractual clause to interpret or draft. What we're talking about here is the common law doctrine, which has been developed by case law over centuries. And so what counts as a frustrating event? Generally speaking, what we're looking at is an event which occurs after a contract has been entered into, but is so fundamental as to be regarded by law as both striking at the root of the contract itself and entirely beyond what was contemplated by the parties when they entered into the contract. So the key point is that the event that has occurred is not at the fault of either party. So the event is one which renders the further performance of the contract or the party's obligations either to be impossible, illegal, or it makes it radically different from that which was contemplated by the parties at the time that they entered into the contract. So it's not going to suffice if there's an event which has occurred which just makes it more difficult or less profitable to perform obligations under a contract. And a useful illustration of this was a group of shipping charter cases that arose out of the Suez Canal blockades in the 1950s. So parties tried to argue that their charters were frustrated because they could no longer sail through the Suez Canal because of the general Nasser blockade in the 50s. I don't know if anybody's seen the episode in The Crown regarding that. And so effectively, because they couldn't sail through the Suez Canal, what they had to do was sail around the Cape of Good Hope, so at the bottom of South Africa, in order to make those journeys to South Asia, to the Far East. And what parties tried to argue was that the contracts, those charters, have been frustrated because nobody could have foreseen that. And what the courts determined was that no, you can still perform the charter, it's just that it's going to take longer and be more expensive to perform. In respect of pandemics and COVID, there hasn't been any decided cases in England confirming that pandemics or COVID will amount to a frustrating event. There was a case in Hong Kong that arose out of the SARS epidemic, so back in 2003 when the SARS epidemic started, and so basically what the Hong Kong court decided in that case, they rejected the claim by the tenant in that case, who tried to argue that his tenancy agreement should be frustrated because what the Hong Kong authorities had done was put an isolation order in place. And what the court said, well, actually, that isolation order was only in place for 10 days and it was a 2-year lease. So it's, whilst he couldn't enjoy his tenancy for that 10-day period because he couldn't access the premises, they said, well, actually, if you look at the long-term nature of the contract and whether or not it's actually radically different from what he expected, that's not sufficient for a frustration event to have occurred. I think given the dramatic impact of the COVID-19 pandemic, there would appear to be scope for the doctrine of frustration to apply in many cases. But again, it will depend on the circumstances. Certainly, respective contracts that were entered into before the COVID-19 pandemic emerged, nobody could have foreseen the consequences. But what will be the key is effectively whether it is the pandemic itself which has rendered it impossible for you to perform the contract or made it radically different from that which you expected to be able to perform at the time that you entered into the contract. So in terms of what you should be doing now, Eric, do you want to take the first couple of points and then I'll take the last couple of points?
Yeah, okay. So what should you be doing now, particularly if you or the other party to a contract is having difficulty performing the contract as a result of the pandemic and these particularly these new restrictions that have been put in place by the government at the moment? Well, the first thing is that you should reach out to your counterparty and be proactive about trying to agree a way forward with them, come to some commercial resolution. Because if you can agree something sensible with them, then that's likely to be the best outcome, or at least a better outcome than any outcome you're ever going to be able to achieve through litigation. So we always suggest that you have some kind of discussion with the other side and try to come to an agreement. But when you're having those discussions, make sure to specify that those discussions are without prejudice. That phrase means that if you say something adverse to your case, that it won't get back to the judge. They won't be able to whether you say it orally or in writing, they won't be able to use that against you if you do end up in litigation. You actually have to say more. I should point out here that for you to enjoy that without prejudice protection, it needs to be part of a genuine attempt to try to come to an agreed resolution of the dispute. But provided that it is, and provided that you specify that the discussion is without prejudice, it's protected in that way. The third thing is that you should review your key contracts to determine whether they contain force majeure clauses and get advice about force majeure and the possibility of the doctrine of frustration applying.
In addition to, sorry, Eric.
Over to you.
in addition to sort of Eric's points as well, you might want to actually just consider whether any contractual notices need to be served, particularly if it could be an advantage to claim that the UK government's second lockdown is effectively a fresh force majeure event, which either entitles you to a further period to suspend your obligations under the contract, or might give you a rise to a possible right to terminate the contract. Again, if I think as Eric stressed before, if you're looking to terminate the contract, then it's probably in your best interest to seek advice on that before you do so. If you're actually entering into new contracts at the moment, or you're actually preparing any amendments to contracts, you might want to consider whether you want to prepare a disruption clause, just in case there are possible future lockdowns or restrictions. Most force majeure clauses include a requirement on the parties trying to invoke the clause to try and perform. Most will say that effectively you've got to try and mitigate the consequences of the force majeure event. Given that we've all been living with COVID for several months now, I think there's likely to be a heightened expectations that firms would have done more to prepare for future disruptions as a result of the pandemic before they can rely on a force majeure clause. I do have some sympathies there when obviously we sort of tend to find out at the last minute about particular restrictions coming in place from the UK government. And another aspect as well that you probably want to consider is actually if you have suffered losses, is whether actually you want to notify any insurers of that loss. If there's obviously a range of commercial insurance policies that various parties have taken out, and that might be relevant to the kinds of losses that are being suffered by businesses at the moment. So it makes sense to discuss with your insurance broker whether the policies that you have in place are sufficient enough that you can actually notify any losses or potential losses to your insurers. And obviously with that, that includes business interruption insurance. I'm not too sure how many people on the call today would have business interruption insurance. And obviously we're all waiting for the Supreme Court decision on the test case, the business interruption test case, to come out. So I understand the hearing finished yesterday. And I read on the Supreme Court website that the Supreme Court justices know of the importance of the decision, but they've already said that they can't promise that that will be delivered before Christmas. So it's very much watch this space at the moment in terms of the business interruption test case. So that's all from us in respect of questions. So I've got one here about, so what would the effect be if a significant proportion of my employees were required to self-isolate, whether that would be sufficient? I think it really comes to a couple of aspects to it. So it really depends on what impact that sort of loss of staff has had on your ability to perform your obligations under the contract. And obviously depending on the wording of your force majeure contract. I think as we touched on earlier, certainly as Eric sort of touched on, in terms of whether sort of parties have been doing enough to try and sort of manage the expectation that something like this might occur, would be taken into account. So whether or not you've sort of taken adequate steps to protect your staff. I think another aspect will be as well is what could you do to effectively mitigate the consequences of the staff having to self-isolate if they're able to work from home and can effectively perform their role from working from home, whether that would be sufficient for you to allow you to perform your obligations. Obviously there are certain jobs that can't be done from home, and you need to be at work, or whether that be in the manufacturing sector, for example, actually in the factory performing the work. And I can see that parties might run arguments such as what steps you could have taken to replace those staff, with temporary staff, for example. So again, there'll be a question there is actually the skilled labour as to whether or not it could have been replaced on a short-term basis in order to minimise the consequences of the fact that your other staff have been able to self-isolate. So I can see that there could be an argument, but again, it will really depend on the fact pattern.
Okay, somebody else has asked here, if you've already paid for something under a contract and then there's a force majeure event before the thing you paid for is delivered, can you obtain a refund of what you paid? Well, typically, the answer is no under a force majeure clause, because as I was saying before, the remedy that you normally get under a force majeure clause is either a suspension of of your obligations or a termination of your obligations. But in either case, that's of your obligations going forward. So normally, force majeure clauses suspend or terminate the party's obligations going forwards from the moment of the force majeure clause. They don't provide for the unwinding of the contract and things that have already happened under the contract, the paying back of money that's already been paid, and that sort of thing. But that may not be the end of the story, because even if you can't rely on a force majeure clause to get your money back under a contract, you may be able to bring some kind of restitution argument, particularly if there's a claim for what's called unjust enrichment, if you've paid for something but not had any of the benefit of it, particularly if there's been what's called a total failure of consideration, so you've had absolutely nothing of value in return for the money that you've paid under the contract. You might have a restitution claim. And also, if you can also make out the separate ground of frustration that Mark was describing, then there is an Act of Parliament called the Law Reform Frustrated Contracts Act, which applies to most kinds of commercial contracts and provides for the adjustment of contracts that have been frustrated by setting out a few different rules for things like the refund of money that's been paid under a contract which is subsequently frustrated. So there might be some other options there other than the force majeure clause. Okay, somebody's asked, can force majeure be claimed over a section of the contract, or must it apply to the entire contract? It's an interesting one. I think that is in principle a question of because force majeure is a creature of contract. It's about what the parties have agreed, and so I think it could, in theory, apply to only a section of the contract if that's what the clause provides, if that's what the force majeure clause says. But I've never seen that before myself. All force majeure clauses that I've ever seen all apply to the whole contract rather than just a section of the contract. But it just sort of really highlights the point that force majeure is a creature of contract, and basically it all depends on what the parties have agreed in the clause.
Eric, I suppose there'll be an element as to what obligations are effectively being impacted by the force majeure event, and I presume the question is driving at there's several obligations under the contract, and one set can't be performed because of the event. I think it'll be really a question then as to whether or not that'll be sufficient to then suspend the other obligations being performed. So it's probably a question on the factual pattern as well as what the provision of the clause says.
Okay, I think maybe we should it's 3:30 now, so we should perhaps call it a day. Mark, are you going to let us know what the next installment of contract conversations is going to be?
Yeah, so on the next contract conversation is going to be on Tuesday, the 8th of December, where Jonathan Christie and me are going to discuss reasonable endeavours clauses. And just a quick recap on the types of reasonable endeavours clauses that you have in contracts, and effectively what the courts require you to perform depending on the words which are used in those endeavours clauses. So I hope that you're able to join us for that. hopefully when you log off on today, you'll receive a quick poll just to let us know your thoughts about today. Again, if there are any topics that you'd like for us to cover off within this series, then we'd be delighted to hear from you and any suggestions that you have. And again, if there is, if you've not been able to raise a question today, then please feel free to contact us if you've got any queries or if we're able to assist in any way.